today, because it is a 3-member tribunal as per the Act, but as on date, a single member, that too outside the field of law, is sitting and issuing notice and deciding these attachment proceedings.
This is with regard to what?
Well, this is in regard to the attachment. Well, this is a mentioning for only listing. The file may not be here. I am so grateful.
Promotion, item number 1.
My Lord, may I make a mention for in regard to item number 8 of part 2?
Yes.
Yes, I have been requested by Mr. P. Goswami. He is unable to appear today. So,
You are here.
but he is leading.
He is for whom? He is for the
respondent number 5.
respondent number 5.
Yes, there's some difficulty.
No. Oh, why?
I have circulated, my Lord.
Have you got any objection to the delay being unknown?
No, this is regard to part 2, item 8.
Oh,
hearing
part 2.
list. Yes, item 8, hearing list.
Oh, I think you made a
Adjournment
slip, no?
Yes. Yes.
Okay.
Yes.
Adjournment slip, yes. Okay,
Yes.
right. On the prayer for adjournment made on behalf of the respondent number 5. List the matter. When?
After vacation.
What is the matter about?
The land acquisition matter.
After vacation.
I am obliged.
You have taken the consent of the other
Yes,
side?
everything in the slip. Yes.
Item 1, please.
Yes. Just a minute. Yes.
Lordship, allow me to furnish these documents for your kind provision. My Lord, today we will consider that regarding whether stay should be granted or not. My Lord, allow me to submit very brief fact on my part.
Yes.
My Lord, if you kindly go to page number 97, that advertisement. 97. This is junior grade of MA, H and VS.
Yes.
So advertisement was published on 11 September 2025. My Lord, a very important point here is 97.
Yes.
6.1 educational qualification.
Yes.
So here the mandatory educational qualification is degree and registration. Here the one "and" is very important. And registration with Mizoram State Veterinary Councils or Veterinary Councils of India. This is the crux of the case. This is mandatory to have this registration certificate. Your Lordship, I have furnished you how it looks in the portal, MPSC, the screenshot.
The portal.
Yes.
Yes.
So this is when you log in, this one, it will come. This is one-time registration. So, my Lord, and in the second page, you will find others. This is where you have to enclose that registration, veterinary, and that certificate. So, my Lord, others, in that others.
Why in the
My
others,
Lord,
what is there?
this is, my Lord, common portal.
Supposing we click on the others, what will come out?
Yes, my Lord. When you click others, it will come. And you will see again that here council registration certificate, you have to click and upload that.
Upload any relevant documents from the above list of others. So others can mean anything.
My Lord, it is not. My Lord, as per the rules and advertisement, it should be that registration certificate.
No.
And if you kindly go to again the last one, you will see how instruction was given at third page. How it looks in our portal.
Upload any from the above list. It's not user friendly at all.
My Lord, actually, I'll explain that. MPSC portal, it should be user friendly. They should use in a mobile phone, iOS, and Android, even internet also. That is one-time registration, only that. So, my lord, that the rules is very clear and that mandatory provision is there, that registration certificate, and my lord, if they click that others, that it will come, because that to prove
In others, what will come?
it will come, others it will come here, add file to upload, select file to upload.
No. When you click others, does the words registration with Mizoram State Veterinary Council or Veterinary Council of India, does it come?
My lord, then they have they have to specify the council registration certificate.
Where is that? Why didn't
My
you?
lord, then
why
in the
why
third-
did you bring that
In the third one, it is there.
in the third one?
Page number.
At a council registration.
Yes. Because my lord, others can do, even they are successful, others who successfully uploaded their documents. Why not them?
I don't know. That's why I'm going to
Because
ask them.
that's why it is there, and also my lord, it is there and they follow and that instruction. If we deny,
How many candidates were rejected?
my lord, 70.
70.
Yes.
How come?
My lord,
I can understand if one or two were rejected or a minimum was, but 70 to be rejected and only 4 to be called for interview. That does not show the portal to be in very good light.
my lord, again, if they have any problem, there is a helpline in the advertisement itself. Yet that the last one,
Yes.
99. Page number, my lord, from the petition.
99,
Yes. In case of query clarification regarding their applications, candidatures, etc., candidates may contact MPSC helpline number such and such on working days between 10 a.m. to 4 p.m. So, my lord, if we give them opportunity to submit again, what will be the fate of others who rightly submitted the documents as per the advertisement?
But
Our hands are tied. We cannot travel beyond our instruction.
Okay, we understand. For you, your hands are tied.
Yes,
Now, so that is your case.
yes,
That they did not submit within time
yes,
and so they were rightly rejected.
yes,
Correct.
yes.
Now, what about the one issue that he has?
Oh, that, my lord, that para 7 clause 2 of MPSC regulation, they have to inform within 10 days in
Yes,
writing.
Yes.
My lord, actually that by mistake, they referred that provision. That provision I have enclosed also, my lord, I have given to you. That 2018 was annulled and superseded by another guideline 2023. I have, my lord, I have furnished to you.
23. Yes.
There, my lord, 2020.
Have you given a copy to the other side? You should give copies to your opponents also.
Actually, my lord, I don't know. I also have some. I kept asking them. This guideline, it is private circulation. So because in that some provision they put by designation their roles and duties. If in Mizo we are very friendly, if they know that particular person, they might contact. They are afraid. So this is not a free circulation.
Oh,
This
then,
one.
Then then that is against you.
No, my lord.
That is, if it's only private circulation, then this goes against you.
No, my
It
lord.
should be known to them.
Even that earlier rule, it was uploaded. And that 2000 rules which they referred was even saving clause, if you kindly see at very last one. So that 2018 rules was repealed.
No, Mr. Counsel.
Why not that 42, para 42. Very last para.
But you said that this is only for private circulation. If it's for private circulation, then they don't know about it.
But anyway, this is their guidelines, which they follow.
Maybe, but a law which is known only to you.
But the one
Doesn't
they
have
refer
anybody.
is also for private circulation.
Maybe, but they have got it somehow.
Yes.
But they don't have this. So anyway, so this is 2023. Where is this is just a typed copy.
My lord, that extract, not the whole book. My lord, in the but corresponding provision is
Mr. Counsel,
11.
there is no signature. Who is this? We don't know. There is no signature in this. This is a document without signature.
My lord, I have the book also.
You have it, you keep it. That's the problem. You are keeping everything only
Well,
for
that is actually-
under lock and key for
My
yourself.
lord, this
only.
is the rules. It was gazetted and it is with them. And the corresponding rules is Rule 7.
These are rules. Rules are not to be kept under lock and key. Only for
No,
you.
guideline,
to see
my lord, it's
In
guideline.
the secrecy of your bedroom or your office. It's for everyone.
Yes.
There's nothing.
It's
secret.
guideline, your lordship. At the
Whatever.
title itself.
Guidelines is for what? It's not only. Is it only for you or not for anybody else?
So, my lord, corresponding rules is at Rules 7, which they referred. Because now the trend is different. Because earlier they used physical submissions of the application form. Now that there is a paradigm shift from using physical one. Now only online they use. If you kindly see para 7.
Unfortunately, you have not given me para 7.
My lord, it's there.
It's there with you, not
My
with
lord,
me.
I have given to you, lordship.
Show it to him.
From 11.
11 is not 7.
My lord, no correspondence.
No, Mr.
what-
Counsel, let us be very clear. 11 is not 7.
No, my lord,
But
my
you mean to
submission-
say that 11 here corresponds to 7 here?
No, earlier they referred para 7 of 2018. That para 7 of 2018 corresponding is that para 11.
Okay, see that. You said para 7. So I was looking at para, there's no para 7 here.
Yes.
Anyway. Yes.
Yes. Duty of examination direct recruitment section after last date for submissions of form. In case of offline submissions of applications, daily receipt of applications submitted by the candidates may be submitted by the reception duty to examination direct recruitment section half an hour before closing of the office. For this purpose, a register should be maintained at the reception counter. After last date for submissions of applications, examination direct recruitment section shall scrutinize all application in minute details. Any incomplete application shall be summarily rejected. After scrutiny, the examination direct recruitment section shall put the concerned file to the chairman for fixing the date of examination along with a statement showing the number of valid applications and those liable to be rejected.
Okay. Only problem is your para 11 talks about offline
Yes,
and this is online.
my lord, that's why this
That
para 7 of their reference is also they could not rely upon because they submitted online only. That para 7 of the old rules is only for offline.
Only for offline.
Yes, they cannot use it. And my lord, if you kindly see that the order which I have given to you, the last one, order 29 May 2026.
Let us see the that para 7 of the earlier notification page. You have got the entire guidelines.
Yes,
Yes,
it's
my
there.
lord.
They haven't
Page,
closed, my
page.
lord. It's at, my lord, 50.
Yes.
And 7, it's start
Guidelines
from-
and the amendment is that, my lords,
amendment
page
is
number
at-
556, my lords. 556, my lords.
And where is that? You said page 100, 200 and? That 200, 2013?
2013, I have given to your lordship.
Which
The loose file.
which page? You had just told me one page just now.
But that the same one, that one is the old one. And
Old
it is
one,
amended.
2013, which page?
50, 56, 50, start from 50.
50.
Even I think that was not signed also. We both prefer unsigned. Guideline.
So all your documents are all unsigned documents, and you're applying them unsigned documents.
Even they also rely upon unsigned.
You are a constitutional body. He's a private individual. It's a major difference. Come to page 53. Read 5B, application form and fees.
Yes.
5B,
5B,
page
online,
53.
online submissions
Of applications.
So
Enough.
for the advertised
Online,
post.
enough, yes.
And my lord, no, the last order, 29 May, kindly see that. Because
29 May.
because their allegation is that they have not responded our representation at all. Because MPSC, they shot and decided and they passed effective order. They have not challenged this one. Very minor, very detailed, the fact of the case, everything.
My lords, I'd like to make a clarification regarding this.
Just give you time, don't worry. Let us give them time also.
My lords.
Heaven is not going to fall.
It was uploaded on internet website and posted on our official website and Facebook also, Instagram also. Here, the fact, everything, this
What?
is judicial decision.
You file this in affidavit. I cannot take the entire thing at one go right now.
My lord,
I think I've heard you.
as of now, my lord, my submission is regarding stay.
Yes, yes.
And regarding stay,
I'm giving a stay order.
My request is that let it goes and as it on 10/6. And also, my lord, as if they had valid documents, because those who
You want
already...
them to participate in the interview?
Yes, then let them participate, those who are qualified only.
Yes, yes.
Because we have the results, everything.
Okay.
So it will go ahead and it can be subject to outcome of the
Okay.
case.
ठीक है. That's good.
So that we will not derail the process also, because along with this, another
But
exam...
no appointment order will be
Definitely, my lord. Another exams also being along with this process.
Good.
My lords, I'll have to object to this, my lords.
Why?
Because as it is, the guidelines of the guidelines of the MPSC clearly states, my lords, guideline number 31, my lords,
Mr. Counsel,
my lords.
you see, now for the only those persons who have qualified will participate. Well,
My lords,
even you,
This
whoever
is their prayer also, my lord.
That's all.
My lords,
Those
the problem is,
just a minute.
my lords,
Who are the people who have qualified? What is the qualification? What is the qualification?
Not the marks. The marks,
What
we
is
have the marks.
What is the
We have
mark?
not published yet.
You're not
Yeah, but it can
the
come.
qualifying marks is there.
It's
correct?
there.
So whoever gets the qualifying
Yes.
marks should be allowed to participate.
It can
That's
consider
all.
as if they have valid
Correct,
certificate.
correct. Yes. What have you got to say?
my lords may kindly come to page number 50, that is the guidelines, my lords. Guideline number 31, my lords.
Page 50.
Page, that is the guideline, my lord. I'll take your lordship to the relevant page. That is at page number 40, my lords. Page number 40.
Yes.
This is the guideline
Page
number.
40 is your prayer.
I apologize, my lords. That is page number 89, my lords. Page number 89. My lords there? Page
Yes.
number 89.
Yes.
This is guideline number 31, my lords.
Yes.
And this states this guideline specifically
89.
states. Page number 89.
Yes, yes.
My lords will find that this number of vacancy and the number of candidates that
Yes.
can be called for an interview will be as follows.
Mr. Counsel,
My
that will
lords.
depend upon if you qualify,
My
if you get the pass
Correct,
mark.
my lords, correct,
That's
my
all.
lords. Correct, my lords.
They will follow this. They have to follow. They have to follow the guidelines. If they don't follow, you come again in a different writ petition. How does it matter?
My lords, one thing is clear from this, my lords. The mode of selection at this point, my lords, only 4 candidates have been selected, which is not,
Mr. Counsel,
my lords,
you are being allowed to participate in the interview.
my lords.
Now,
Subject
what
to his
more do you
qualified.
want? What more do you want?
My lords, our main point is that, my lords, when the selection was made, my lords, initially, after the written examinations, the result of the written examination was published, my lords.
Huh.
And initially only 3 candidates were selected, my lords, which is on the basis of that, these candidates have submitted their registration certificate, my lords. And thereafter, my lords, an addendum was issued again, my lords.
They are making no sense. What
My
is
lords.
the marks have been published?
Published, my lord.
What is the pass mark for the written exams?
My lord, minimum.
You tell me the pass mark, and all those who get the pass mark will
Yes.
will be
My lord, here
called for interview. That's all.
at page number 47 and 48, the pass mark is 365.34. 48, page number 48. You kindly see
Page 48.
48.
Page 48.
Yes.
Cutoff
The
mark
B,
is
the
365.
cutoff, yes.
Page 48. Okay. So whoever gets this in the written exams
Yes.
will be allowed to participate.
That's fair enough.
That's
That's
all. Right. Heard. Mr. Lalchan Asylum, learned counsel for the petitioners. Also heard Mr. J.C. Lanusama, learned counsel for the respondent number
3, 4, and 3, 4, 5, 6.
who is that? MPSC?
MPSC secretary. No, my lord. 4, 5, 6. Chairman, secretary, and controller. 4, 5, 6.
For respondents number 3, 4,
My lord.
5.
My lord. 4, 5, 6.
Not
4, 5,
3,
6.
not 3, cannot be 3.
Yes.
4, 5, 6. 4, 5, 6. Bracket Mizoram Public Service Commission. Who appears for 1 to 3?
My lord. Mary.
Miss Mary L. Kiangte. GA appears for the respondents number 1 to 3. Where is the impugned order?
My
Page
lord.
number 46, my lords. That is the notification, my lords.
Huh? Which one?
Page number 46, my lords. This is the written examination result, my lords.
Where is the impugned order saying that you are disqualified?
My lords, there's no order, my lords.
I thought they were not
My
called
lord,
for
actually,
interview.
they have to challenge that May 29, or that is the
My
impugned
lords,
order.
my lords,
that I
may
have
just give me a
furnished
moment,
to
my
you.
lords.
Just a minute. Yes?
They have to challenge that impugned order. This is the impugned order
Which one?
that I have furnished to you. That order passed by the commission.
Okay.
Yes, they have not, because there is no impugned. They have not challenged any order here. They have to
No, but
challenge.
then you should have called them then. Acha, this they have not.
Yes.
They have not.
My lords,
They have not challenged. It is there in official website even now also. Decision, everything was there.
Okay. So this is not challenged.
Not challengeable.
Why have you not challenged
My
it?
lords, I'll gladly come to that. We had filed this petition on the 29th morning, my lords.
29th?
And this was issued on the very same day, my lords.
Okay.
They have copy also. We had given now.
My lords, it was on the same day that we had
Anyway,
received this
so
copy, my
you
lords.
challenge this by
My
way
lords.
of additional affidavit.
My lords.
In the meantime, all those who have got the required benchmark shall be called for the interview.
That's fine. We are fine with that. Your Lordship.
But then you have to give today is the 4th. Will they have time to study?
My
Right.
lords, as per the guidelines, 11 candidates may be called, my lords.
None of that.
The 11 candidates is necessary.
You want only
necessitated
11?
by the candidate by the guidelines, my lords.
Sorry, Mr. Counsel.
My lords, it is as per the guidelines of the MPSC, my
You,
lords.
huh?
It is as per the guidelines of the MPSC, my lords. 11 candidates for 4 posts, my lords. I'm not making out of this. I'm not making.
For the 4 posts.
Yes, for 4 posts, 11 candidates must be called, my lords. This is as per the guidelines, my lords.
My Lord, actually,
Guideline number
it's
31, my
better
lords.
if you call
Then
the
if you want 11 candidates
It's
for
not
the
good.
guidelines, how many of them have got the benchmark?
That would have to be considered.
No, please.
My lords.
You calculate now. How many of the writ petitioners, how many writ petitioners are in this case? How
63,
many
my
writ
lords.
petitioners?
63, my lords.
Huh?
63,
63.
my lords.
And you want 11 of the writ petitioners, 11 out of the 63, or you want 63 writ petitioners to participate in the interview. What do you want? What
My
is
lords,
your prayer?
My lords, 63 should participate. My lords.
Please be very clear
My lords.
as to are you appearing only for 11 or for 63?
I'm not, my lords. I'm not, my lords. My lords, may kindly allow me to explain this, my lords.
Huh?
My lords, as of now, only 4 candidates have been shortlisted for the personal interview, my lords. Now, we are 63 of us, my lords. And after being shortlisted, and depending on the merit, my lords, 11 candidates must be called for the personal interview. That's all I'm saying, my lords.
11 candidates.
Out
11.
of-
So you calculate. I'll give you half an hour. After half an hour, you tell me which are those 11 candidates which should be called for interview from your list of writ petitioners. We will record your statement.
I'm sorry to antagonize, my lords, but then...
No, it's not a question of antagonizing. This is a question of your prayer, and we will say that these are the persons who should be called for interview
My
as
lords,
per the list.
That is the job of the MPC,
No,
my lords.
we are asking you to do it because you are representing 63.
Correct, my lords.
So that is why, please tell me which of the 63, out of the 63, which are the top 11? This is the order of the court to you.
I apologize, my lords. That would have to be considered by the MPSC, depending on the merit, my lords, of the written examination, my lords. And that is not in our possession, my lords.
No.
That is not for us to decide,
Huh?
my lords. That is not for us to decide, my lords.
Then I'll go by this notification that has superseded that notification. This is of 2023. In 23, there's no question of 11. What are you playing? What game are you playing? I don't understand. You are playing, you have got the marks. You have
Correct,
got the
my
marks
Correct,
for all the candidates which is in this writ petition.
my lords.
But now you want only 11. Why have you taken 63 petitioners as your clients? Why not take only the top 11?
My lords,
What are you playing? What game are you playing?
Actually,
You're playing the money game.
my lords, all I'm saying is, as per the order and the notifications, only 4 candidates has been called so far, my lords.
Yes, 4. Now, supposing, forget the 4.
Correct,
According
my
to you, only 11 are to be called for the interview. Correct?
Correct, my lords.
If the 11 are to be called, as per the marks given by them, which is in your possession, which is here,
My
next to the petition,
My lords.
only the top 11 will be called. Out of the persons who participated in the written exam, only 11 should be called.
That is as per the guidelines, my lords.
That is what you are saying.
My
What do you
lords.
mean as per the guide? That is what you are praying for. Now, if you want the top 11 to be to participate in the interview, why have you taken 63 clients? Who are all 63 cannot be in the top 11?
My lords, the simple reason is we have
What is
been
this?
our
Yeah,
candidature, my lords, our candidature.
Mr. Counsel, be
My lords.
fair not only to the court, be fair to your clients. Totally unfair. So sad to say. You You have taken fees from 63 petitioners and you are saying that only 11 should be called for interview. Why did you take the, why didn't you stop after the top 11 were your clients? Why did you take the others? For what? Taking them for a ride? Allah, you be a part of the petition. Though I'm not going to ask for your participation in the interview and there's nothing for you to gain, but I'm taking you along. What are they going to gain by being a petitioner, by being petitioners? What kind of a game are you playing?
My lords, I'm not playing any games.
You
my
are
lords.
playing. That's what
My
I've
lords,
noticed.
This is just
You
a
always-
result.
you
my lords.
always
The
seem to
marks-
be playing
even the
games.
marks- Even the marks are not here, my lords.
Huh?
The marks are not given here, my lords.
Marks? What do you mean?
Only the selection,
Marks are not
only the
given
selection
you?
of 3
My lord, we
candidates
have
are
the
given,
mark
my
there.
lords.
We
The
have the
marks are
mark.
not given, my lords.
We have the mark at the office, then we can call those who have qualified.
Yes, you give the marks.
Yes.
Since we'll say his prayer,
Yes.
we'll record his prayer
Yes.
that only 11 along with the 4 that has been there.
We'll do it. My lord,
We'll do
office
it.
is very
We'll do
near.
that.
Actually, it's better if we call all cut-off date. It's much better.
Huh?
It's much better if we call
Correct.
those who have qualified.
Correct.
There is good opportunity for
We'll-
them. I don't
we'll-
know why
we'll-
he's
we'll-
planning
My lords,
for
at this
11.
point,
I will just record your, which is your, which para, which is the thing, which page again? We'll record your statement. We'll only call 11 as per your statement.
Yes. That is worse.
Where?
Page number 89, my lords. This is the DMPC Conduct of Examinations Guidelines, my lords.
Okay, whatever. For 4 posts, 11. Okay.
4 plus 7, 11, my lords.
Yes.
My lords, our main point is that, my lords, our candidature has been rejected on the sole basis that we have not submitted the registration certificate, my lords. Now,
We will go by your prayer. We will take 11. We'll tell the top 11 plus the 4 already selected. Then we will consider whether those 4 also, if we find that your stand should be correct, those 4, if they come at 12, 13, 14, 15, they will not be selected, even if they are selected in the interview. We'll ensure that. That is your prayer. Right. Where am I? Huh? Acha, heard Mr. Lal Chandima Silo, learned counsel for the petitioner. Also, that I've done, no? Full stop. The petitioners are agreed by the rejection of their candidatures for the post of for recruitment to the for direct recruitment to the 4 vacant posts of junior grade of the MAH and VS under the Department of Animal Husbandry and Veterinary, Government of Mizoram. On the ground that they had not submitted veterinary council registration certificates issued by the state of Mizoram or the Union of India,
Veterinary Councils of India.
Veterinary Councils of India or the center.
My lord, it just simply says it, Veterinary Councils of India. At page number 97,
97.
6-1.
By the Mizoram State Veterinary Council or Veterinary Council of India. Okay. Full stop. The petitioner's counsel submits that pursuant to the advertisement number 30 of 2025-2026 for direct recruitment to 4 posts of junior grade of MAH and VS under the Department of AH and VS and under the Department of AH and V. Government of Mizoram, the petitioners applied for the said posts by submitting online applications. Full stop. Then according to next next para, subsequent to the submission of their online applications, through the online portal, a valid list of applications were published by the MPSC on 25/10/2025, wherein the petitioners, how many petitioners? The 63 petitioners. How many applications did you have?
70.
70. The 63 petitioners' applications were declared as valid. Full stop. Pursuant thereto, admit cards were issued in favor of the petitioners, and they were permitted to take part in the written examination conducted on 27/11/2025. The MPSC declared the results of the written examination on 27/4/2026. Full stop. However, the MPSC rejected the applications of the petitioners, 63 petitioners, on the ground that they had not submitted their veterinary council registration certificates. Full stop. On the other hand, 3 candidates were initially shortlisted for personal interview to be held by the MPSC on 10/6/2026, and thereafter, one other person was also asked to appear for interview on 10/6/2026. Full stop. Next para. The petitioner's case is that there is petitioner's case is that due to the absence of an option or specific field for uploading their veterinary council registration certificates in the official online portal of the MPSC, they were unable to upload the same, despite possessing valid veterinary council registration certificates. Full stop. Full stop. However, as the MPSC had published a valid list of applications, wide notification dated 24/10/2025, and which included the applications of the petitioners, admit cards had been issued to them, and they participated in the written examination. Thus, it was unfair on the part of the MPSC to now declare the online applications of the petitioners as invalid due to non-submission of their veterinary council registration certificates, bracket VCRC timero, VCRC bracket in short, right close, in the online portal. First. Next, the petitioners council submits that The MP submits that the MPSC, wide notification number A-2/9/2001 MPSC dated 27/7/2018, Dimina order, last order, para 3, had amended the Mizoram Public Service Commission conduct of examinations guidelines 2013, hereinafter referred to as the 2013 guidelines. Para 2 of guideline number 7 of the 2013 guidelines required the MPSC to inform the applicants in writing and grant them 10 days time for rectification of any incomplete application in the nature of non-enclosure of necessary documents or non-furnishing of crucial information. The same not being done by the MPSC could not have rejected the applications of the petitioners. Next paragraph. The Petitioners' Council further submits that in terms of the 2013 guidelines, the number of candidates that can be called for interview for filling up 4 vacant posts is 11, which is reflected in guideline number 31. Next para. The Petitioners' Council submits that in view of guideline number 31 of the 2013 guidelines, only 11 persons should be called, and only 11 persons out of the total number of candidates who participated in the written examination should be called for interview, depending upon their merit position and on the condition that those candidates have secured the cutoff marks for junior grade of MAH and VS in terms of the advertisement dated 27/4/26, which is 365.34 marks. Full stop. Next para. Mr. J.C. Lalnusanga, the Learned Counsel for the MPSC, submits that the petitioners have not put to challenge the order dated 29/5/26 issued by the MPSC rejecting the candidature of the 63 petitioners, writ petitioners, on the ground of they not having uploaded their certificate of registration in the Veterinary Council. He further submits that the 2013 guidelines, which had been amended by the MPSC wide notification number A-2/9/2001-MPSC dated 27/7/2018 has been repealed by way of guideline number by way of the Mizoram Public Service Commission bracket conduct of examinations bracket close guidelines examinations bracket close guidelines comma 2023. He submits that hereinafter referred to as the 2023 guidelines. He submits that the 2023 guidelines it only speaks of offline applications and does not take into consideration the applications that are submitted through the online mode. Full stop. Next para. Mr. J.C. Lalu Sanga, the Learned Counsel for the MPSC, the Learned Counsel for the don't say name, I don't know. The Learned Counsel for the MPSC submits that he does not have any objection with.
Before that, others three also successfully submitted that. You can kindly.
The Learned Counsel for the MPSC also, but you have called four of them. Why have you called four?
My Lord, one, she complained, submitted representation. We check it, we scrutinize, and she submitted. We found that it was submitted along with another certificate. That's why, since it was there in our record, we call her.
No, but she also did not submit it in the online mode.
She submitted on online mode.
Then it was there in the online portal.
Yes,
it was
yes.
there in the portal.
Yes.
Okay. So all four of them were in the thing. All
Yes.
four of them.
My lords, may I kindly allow me?
My lord,
These
four
are,
of them.
these are disputed questions of fact. Anyway, the Learned Counsel for the MPSC submits that the four persons who have been called for interview to be held on 10/6/2026 was due to the fact that they had submitted their online applications along with submissions which included their veterinary, the VCRC. Full stop. Initially, three of the candidates were permitted to undergo the interview. Full stop. However, the fourth one was allowed after a verification was made, after a complaint was received, which showed that the fourth person had also complied with the requirement of submitting the VCRC online. Full stop. Next para. The counsel for the MPSC submits that he does not have any objection with the prayer of the applicant, prayer of the writ petitioner's counsel, which is to the effect that only the 11 most meritorious candidates in the entire selection process should be called for interview. Full stop. However, the four persons who have been found eligible to be to participate in the interview cannot be left out from the selection process, in as much as the question of whether the writ petition would be allowed or dismissed at the time of final hearing would otherwise prejudice the 4 persons who have already been called for interview by the MPSC. These 4 persons are, who are they? Give me the names. I will call only 11 others.
It's for my lord 561.
Huh?
561. Case number 561.
561.
Yes. David Lal Kamwana, H. Lal Ruatfela, H. Vanal Roy, Lal Rem Ruata.
Who are David Lal Samwana, roll number 41309, H. Lal Ruatfela 41320, H. Vanlal Roy 41323, and Lal Rem Ruata 41352. Page 561 now. No? Yes, what have you got to say about this only 11 candidates? How much can be called?
Yeah, 11 is true.
11 is true.
Yes.
So 11 for the post.
Yes.
So you call 11 plus you count the
Yes.
senior most 11 as he wants.
Yes, Lordship.
Plus these 4.
Yes.
Because if you succeed, then they all go.
Yes.
But if they succeed, then from the 11 plus 4 they will be called.
Yes.
From the top 11 they will be called. And if those 4 persons are among the top 11, then they can be selected. But if they are not among the top 11, then they cannot be selected. The interview will.
Yes. Subject outcome of the case also.
Yes. Full stop.
Excellent.
What have I said? Full stop. In view of the above, before that, admit an issue notice. We have issued notice.
Not yet, my lord.
Wait.
My lord, I think that
They are all here. We are all here, so no need of notice.
my lord,
We are
what
all-
about that 4 petitioners and have to be participated for fair
They, no,
adjudication?
we'll make them implead them. We'll
Yeah,
tell them to
that is
implead.
good,
They have
yes.
to be impleaded.
Yes, because they have lots of to think to say.
Yes. They will implead. They will have to implead. Their rights cannot be affected without hearing
There
them.
will be the aggrieved person here.
Yes. Right, next. As all the parties are represented, there is no requirement of issuing a formal notice to the respondents. However, as the rights of the above 4 persons who have been called for interview may be affected, could be affected by the final decision to be made in this case, the appellants the writ petitioners should implead the above 4 persons in this case. Full stop. Next paragraph. On considering the issues, they are considering the issue as to whether the rejection of the writ petitioners' candidatures for participating in the selection process for the four vacant posts of MAH and VS. I think I can share look there. From participating. is correct or not. This court is of the view that besides the 4 persons mentioned above who have been called for interview by the MPSC on 10/6/2026, 11 other persons whose candidatures have been rejected on the ground that they had not submitted their veterinary VCRC in the online portal should also be included in the interview process to be held on 10/6/2026. The 11 persons to be selected should be selected on the basis of merit and only if they have obtained the benchmark of 365. So how much? What is the mark? 360.
My lord,
The benchmark of 365.34.
Yes.
365.34 marks. Full stop. It is also made clear that the 11 persons to be selected on merit minus the 4 persons mentioned above would also include persons who participated in the written examinations but who are not a part of the who are not parties in the writ petition. So there could be some persons who have not filed.
Exactly.
So
Yes.
those persons also you have to consider. Full stop. Full stop. The reason that this court has directed the interview of 11 persons on merit, on the basis of merit, including the 4 persons already called, is due to the fact that if the writ petition succeeds, it is due to the fact that even if the 4 persons have lesser marks than the 11 persons who have secured higher marks than them in the written examination, their rights could be affected in the event the writ petition fails. List the matter on.
My lord, any date?
Full stop. In this respect, the MPSC shall publish the marks obtained by all the candidates and select the top 11 candidates who secured the highest marks for interview. If any of the 4 persons who have already been called for interview are among the 11 who have already been called for interview, necessary adjustments to the number of persons to be called for interview can be made. That means, supposing 1 out of the 4, say he is number 1,
Yes.
then you have got to call 4 plus 6.
Yes.
You understand? Because you already 11, no? So it will be 4 plus 11 right now. Correct. So if say one of them is number 1 in the merit list, then you have to call 11 plus 3 because he is already there.
Yes.
Okay.
They might get even same mark also.
Yes. So whatever you made the
And my lord, it may kindly add, final decision be subject to outcome of this.
Yes, the final the results of the interview shall not be declared without the leave of the court. And That's all.
That's it. Fine.
What?
Fair enough, Your Lordship.
List the matter on. When?
After 2 weeks?
Should we give them some more time for interview?
Sure.
I think it's too.
My Lord, actually, this
Lord,
this
if
is
the interview
along
may be
with all this.
Huh?
If you
If the
kindly,
interview may be preponed or
if you kindly see, my Lord,
Postpone, you mean?
postponed,
It cannot be preponed, postponed.
postponed.
my Lord, actually, this along with this recruitment MHS also, it's going simultaneously. So
You do
the same,
this for them
the same
separate-
time.
on 10th.
Yes.
Okay. But when can you inform them? Today is Thursday.
Today itself, my Lord, actually, in
Today.
fact, they are watching online also. Everyone
No,
knows it.
but do they know their marks? Do they know their marks?
That would have to be published, my lords, before the date
You'll
of the
have to
interview.
publish the marks.
My Lord, actually, when we publish the mark, and everyone will know the merit list. Actually, that normally the practice. That we
Okay,
don't
okay,
have.
okay.
Yes.
So don't publish. Forget publishing the marks as per the thing. You don't have to
Yes.
publish the mark. Cut that publishing part. The MPSC, the Mr. J.C. London Saga submits that the persons, the 11 plus 4 persons who have to be who are to participate in the interview process to be held on 10/6/2026 shall be informed positively by today.
Yes.
List the matter on when?
2
After
weeks.
2 weeks, my lords.
2 weeks.
23rd of June.
Fine. Much obliged, Lordship.
Yes, that's all. Then,
Item number 2.
in the meantime, the MPSC may also submit their affidavit in opposition.
Your Lordship, I appear on behalf of my senior CGC. She has personal difficulties today, so may the matter be listed after 2
Okay.
weeks.
Who is their senior CGC? Okay,
Yes,
on the
my lord.
prayer for adjournment made by the on behalf of the learned CGC, list the matter on. Give a date after. When after?
After 2 weeks.
Give a date.
22nd of June.
Obliged, my lord.
Item number 3.
Lordship, if I may be given some more time to file my rejoinder affidavit.
Madam, what is this?
Lordship?
You are saying there is encroachment on your
Yes,
land.
yes.
What is the government saying?
Government said that they have some dispute, some
There is no
with regards to the
encroachment.
boundary.
Huh?
With regards to the boundary. But they have
So
three
then-
spot verification was already conducted, Lordship.
Then, madam, then what to do? Then you go in a civil suit.
Lordship,
This court cannot decide disputed questions of fact.
Lordship, if I may be allowed some more time to find my reply, that
You have
also
taken
with
enough
regards to the
time.
disputed question of facts, also let I will clarify it in my affidavit.
How can you clarify? You cannot clarify a disputed question of fact, madam. Disputed question of fact
The-
can be
just
clarified by the
because-
civil court.
Lordship,
You see, like you said, there have been 3 verification
Yes.
reports.
Yes.
Now, what more do you want? You want for, and the 3 verification reports, how many are in your favor?
All in my favor.
All in your favor?
Yes. Saying that there's an encroachment.
But then how much? How much?
Lordship,
How much encroachment?
the whole of the land.
Whole of the land?
LS, yes. There's a building.
Then why do you need,
constructed
then why
inside
do you
the-
want to file rejoinder?
With regards to the some statement made that there is disputed question of facts. Lordship, I'm just trying to point that there's no disputed question of facts.
Anyway, I will not go into. Anyway, you see whether you have got a case.
Lordship, yes.
On the prayer made by Ms. H. Dharma Swami, learned counsel for the petitioner, the matter is adjourned for a week to enable her to file a rejoinder affidavit. List the matter on.
16th June.
Deeply obliged.
Item 4.
Please, Your
Yes.
Lordship. In this case, Your Lordship, we have filed a wakalatnama yesterday on behalf of the respondent number 5 and 6.
Who is 5 and 6?
4 and 5, Samagra Shiksha, State Project Director.
You see, it's a small issue.
Yes, Your Lordship. Your Lordship,
Has the petitioner supplied sports goods or not?
Your Lordship, the fact is that the materials were supplied, but they were of substandard quality. So they had
Substandard
called the supplier also, and they had informed her that they wanted to return some of the goods,
Okay.
which have been kept safe in the custody of the
Okay.
office.
So you file a reply.
Yes, Your Lordship.
And then you see what can be done is the admitted amount, say which are of good quality, standard quality, which you accept, that you pay.
Yes, Your Lordship.
The other aspect, so we'll see.
And there was one question of tampering with the prices. Some MRP had been taped over the original.
So probably it has to go to civil court.
Yes, Your Lordship. There are questions of facts.
So you file an affidavit fast.
Yes, Your Lordship.
Okay, right. The matter pertains to non-payment of bills for supply of sports goods by the petitioner. On the other hand, Mr.
Jonathan Lorin Tluanga,
Jonathan Lalit Longa, appearing for
respondent number 4 and 5.
4 and 5, submits that some of the supply materials were of substandard quality and there was tampering with the prices of the goods supplied by the petitioner. He accordingly is granted how much time?
2 weeks, Your
2
Lordship.
weeks time to file affidavit in opposition. List the matter after 2 weeks. Anything to be done by you, madam?
No, Your Lordship.
Obliged.
Item 5.
Item?
Lordship, in the last court date, the respondent number 1 was presented and they were given some time to file their power. But however, I believe they haven't filed their power yet.
Your Lordship, we already sent to the respondent, but still the parties, but still they didn't return the power.
They didn't return the power?
The wakalat nama.
Your client has not given you the power.
Yes,
That means he
yes.
doesn't want you.
No. With the speed post we send.
Huh?
With the speed post we send the wakalat nama.
Okay, he has to sign it and
Yes,
send it
yes,
to you.
yes. That's right. We need some time to.
Okay. So are you filing any affidavits?
For respondent number 2, my lord, no, we will not file.
You will not file.
No, my lord.
What about you? Okay. Mr.
J. Shakil Al-Rotfela.
Appearing for respondent number?
2.
2. And Ms. Vanesiami appearing for? Respondent number 3. Submit that they will not be filing any affidavit. Mr.
Avinash Guru.
Avinash
Guru.
Guru appearing for? Submits that he will be appearing for?
Respondent number 1.
Respondent number 1. Full stop. He submits that the Wakalat Nama will be filed by him within
2 weeks.
2 weeks. Along with affidavit in opposition.
Yes.
List the matter after 2 weeks.
Much obliged.
Item number 6 and 7.
Yes, may it please your Lordship.
Yes.
Lordship, in this matter, as recorded in the order dated 7/4/2026, all parties agreed that this IA 135 of 2025 and the main petition shall be taken up together for final disposal. But, my Lord, in the meantime, pursuant to the observation made in the order dated 28/4/2026, my Lord, I have filed
In the writ petition.
yes, in
What is the observation made?
the observation is that the authority, that the competent authority shall be implemented. I'm seeking for that.
Where?
I have filed the IA, my lord.
In IA?
Yes, IA. Another IA.
Item?
number 7.
This 55. IA
110.
55.
IA 110 of 2026,
Okay.
my lord. There are 2 IAs.
Yes, IA. Okay, right. Miss,
Rosie Manlomsangi, my lord.
appearing for the applicant, writ petitioner. Praise that the competent authority for land acquisition bracket Kala, comma, Longklai district, Longklai, Mizoram, should be implemented as respondent number 10. In the writ petition. Mr. P.J. Saikia, learned senior counsel for the
Respondent number 2, 7 and 8.
respondent number 2, 7 and 8, and
Lordship, I'm appearing for respondent number 3 to 6.
Miss Kelung, Rosalind Kelung Oipui appearing, Caroline Kelung Oipui appearing for respondent number 3 to 6, and Mr.
On behalf of CGC correspondent.
Liadmintang on behalf of the CGC, submit that there was no objection to the same. Accordingly, the prayer is allowed. I,
For respondent number 9, sorry.
Miss, what is your name?
Sabita Sarna, SARNA.
Sabita Sarna appear for respondent number 9. Submit that there was no objection.
Respondent number 9.
Respondent number 9. There was no objection to the same. The I is accordingly allowed. Applicant to submit a corrected copy of the cost title
Yes, my lord.
in the registry within 2
within-
days.
Yes, sir.
Try tomorrow?
Next week, yes, my lord, tomorrow is if it's possible, my lord.
Possible?
Yes, my
Okay,
lord.
within 2 days. And then within 2 days. Then we have to issue notice to Kala also then. Then right. In view of the order dated today, passed in IAC 110/2026, Kala so and so has been implemented as respondent number 10. Issue notice to Kala, issue notice to respondent number 10, writ petitioner to take steps for service of notice upon the respondent number 10 by speed post and by usual mode within 2 days.
Within next week, if possible.
Okay, within 4 days.
Okay, my
Within
lord.
4 days. Leaves the matter on. Give a date.
Obliged, my
May I
lord.
pray for 25th of June?
Huh?
4th week of July,
4th, give a date.
21st, if not inconvenient, 21st of
21st.
21st of July. 21st.
21st of July.
It will come up for admission. Notice.
Okay, let the matter, on which date the matter should be listed in the admission column. Any problem, madam?
Your Lordship, no. In fact, our application, the argument was already happened and it was meant for the last time for disposal of the writ petition together on the consensus of the party. Even the writ petitioner also mentioned that our presence is not required. But again, by this impleadment application, we are dragged into the litigation. So my humble request is if we can be, I'm not sure about, of course, the process, but if we can be exempted, we have no role to play.
Yes, what
my
about them?
statements are not recorded.
Have they got any role to play?
But she has been implemented by the writ petitioner by filing an IA.
Why? What is the role to be played by this JICA? What is this?
JICA.
Jai-
Because
Jai- JICA.
JICA has funded the amount,
So,
and they have played an important role in this.
they are only
case, my lord.
the, so supposing AIDB and the World Bank fund some project in Mizoram, you will make them parties.
Yes.
In fact, Your Lordship, my statement, my affidavit has already filed, and the last time, and Your Honor has already recorded. If you see the copy order dated-
Recorded where? Recorded in where? In the main in the main
Yeah,
petition?
let me just show you, Your Lordship, order dated 7th of April, Your Lordship.
Yes.
7th of April.
In fact, it was full-fledged argument happened on our deletion application.
In the
and
IA, in the
fact-
IA or in the IA or in the writ petition?
In the
Yeah,
writ petition, no, sorry, Your Lordship, in the IA 135 of 2025, And even writ petitioner agree that if we are not contributing or compensating to money for this project, so we have no objection. Your Lordship, if you see the order of 7th April, let me just, if you want, I can read the relevant paragraphs.
Yes.
Yes, Your Lordship, if you see, the Lordship has recorded during the course of deliberation, a consensus has been arrived by the council of the parties that entire writ petition can be taken for the disposal of the convenient time. By my application, the decision was not given because they thought they will be able to dispose of the writ petition. But they recorded, if you see the next paragraph, Your Lordship, the learned counsel for the applicant of IA, which is us, Japan International JICA, has submitted that it would be reflected from the content of the IA itself that guidelines laid down by the JICA's requirement, relevant law of the land to be followed, and the guidance do not act as a supreme over the local, state and the central law of the concerned department. So, Your Lordship, whatever the compensation is, whether 2013 Act will be applicable or not, it is for the Your Honor, you need to decide, Your Lordship need to decide. Whatever is been adjudicated, I have no role to play.
What is your role? What is your role in this entire affair?
I am a sponsor. I am funding the project, and as per my loan agreement, which was shown to Your Lordship during the hearing, because of the nature of the document was confidential. He has noted that my compensation, the claim of the petitioner that they are looking for the compensation was not properly calculated. Neither I am evaluating, nor I am disbursing any compensation with regard to this acquisition of immovable properties. That is the responsibility of this executive agency. So, Your Lordship,
Madam, I don't think they are a necessary party at all.
That, my lord, we have implemented this JICA due to the suggestion of the court order dated 30/4/2024, my lord.
34/2024?
24.
In the IA? No, in the main case.
In the main case, my
In
lord.
the main case.
Paragraph number 3, my lord.
Where?
Paragraph number 3. If I may read it out, my lord.
So the government is taking the stand that the compensation has to be paid as per the JICA guidelines.
Yes, my lord.
Is it? How can it be? You've got to follow the law of the land.
My lord, the entire scheme, my lord, has been funded by the
Maybe, but
JICA
then,
loan. So therefore, the state has accepted. The JICA had certain conditions. You have to follow, my lord, these guidelines. Accordingly, state has said yes, we will be complying with.
But the state agreement with JICA has to be within the contours of the law applicable. It cannot be beyond.
Yes, cannot be beyond.
Then,
Now
so that the whatever agreement the government has made with JICA cannot go beyond the law.
Now the issue in the writ petition, whether they will be entitled under the 2013 Act or my lord under the JICA matrix. So far as JICA matrix is concerned, that has already been deposited. They have received. They said it is less. Had it been under the 2013 Act, they would have got better, my lord, RNR.
Anyway, that is nothing to do with JICA. So JICA's role is with the government, which they have done. Now the government, if they are trying to follow JICA, then they have made they have made a mistake. They have got to follow the law. So whatever additional amount is required to be paid has to be paid by the state.
By the NHIDCL or the Union of
whoever. So I don't think JICA is necessary, though the government is taking the stand that they are bound by the agreement made with JICA. That agreement cannot be against the law of the land.
My lord, that agreement, they did not annex anything about their agreement. They did not.
How
annex
does
the
it
document.
matter whether they annex or not? The law will prevail. Just because they have made an agreement with XYZ doesn't mean that they can use that agreement to violate the law. They cannot. Any agreement made in violation of the law will have to be will be subject to the law. You see, this agreement is between government and JICA, so that is between them. But the executing agency is the government. Government will have to pay as per the thing, as per the law, not as per their agreement with them. That is not that agreement cannot supersede the law. Anyway, one thing is I think
Your Lordship, my humble request, in fact, if you want, I can even show my JICA guidelines which was shown to the Your Lordship last time also, like to the judge concerned. They are saying JICA guidelines, they have calculated as per JICA guidelines. My JICA guidelines says that host country, I have a contract loan agreement with the Government of India. Government of India, I am funding this almost 340 project I am funding in India, and even Northeast region also I am doing lot of project, and my loan agreement specifically says I am not going to compensate on the acquisition of the land. That is the responsibility of the concerned state, and my JICA guideline says you need to follow, which follows, as Your Lordship also rightly observed, like World Bank. It specifically says the host government has to follow the law of the land. So that JICA guidelines is applicable universally worldwide, not only for India. And a humble submission which I have submitted to the Lordship, and because he heard the matter and he returned that document, if you want I can show it to the online, that it is not required. And after concessions, in fact, Petitioners Counsel, who was present that point of time, I think Mr. Joseph was there, the senior person, he mentioned that yes, if they are not compensating to the compensation, I don't think then they are required to be party to this. My name was not dropped on that day, only on the presumption that next date we will be able to dispose of the writ petition which has been recorded in the order. So now having a new impleadment application, that means for another 1 hour, the process of all the counter, affidavit, etc. will be there, and I am unnecessarily dragged into. See, this will actually really, my power to invest and power to work in India is really, I become very demotivated where I am unnecessarily dragged into litigation.
Correct.
In fact, one of the matters.
No, yes, I understand the issue. The only thing is that I need a document. Who is your counsel here? No one. Mary.
She's there, Lordship.
Mali is there. Oh, Mali is there. Mali, why are you hiding?
Lordship, since I haven't signed the Vakalatnama, although I'm the
you have not signed.
Yeah, I have not signed the Vakalatnama, so it's improper for me to.
No Vakalatnama has been given to her, it appears.
No, I'm assisting them, Lordship.
Assisting them.
Your Lordship, we have a slight misunderstanding.
She marries there, Your Lordship.
Go there, you're the side.
Yes.
You're the side. Yeah, both of you, Mali, you're the side also.
We were, I have signed a Vakalatnama, but my learned friend is assisting me in the case. What happened is that we do not have any grievance with the JICA. The state do not have. Because the state is an agency. It is a contract between the Union of India and JICA. So in the last court date, they have submitted the confidential documents. That is the agreement between the Union of India and
we'll incorporate that here, the small portion.
Yes.
And then we'll have, where is it?
It's with Madam Savita. So maybe yes, tomorrow.
Because of the confidentiality reason, I was not directed to submit, but I had shown to the Your Lordship during the last hearing. If you want,
at least we could. We don't have to reproduce the entire agreement. We just want that portion which says that the acquisition issue is the subject matter of the state, and that you will follow the laws of the land. That's all. then we can close this matter, because you see, when you file these types of cases, it has repercussions.
Yes.
Because of your one small case, it can affect a lot of investors. So you all are thinking, you all cannot think of things only in a very micro sense. You've got to think slightly broad, because it doesn't really have any effect on your case. They've got nothing to do with it. It is basically, land acquisition is basically an issue between the state and the individual. Article 300A, the various land laws, it says the state, or the authority that is acquiring the land. Okay, so that is the issue.
Your Lordship, may I suggest if an email could be provided?
You provide it to you, provide to me. We can list it on Monday also.
Because since it's confidential, then it will
we
be
can
for
list
your
it on Monday
perusal.
also. Or tomorrow also we can list, that is not an issue.
Yes.
In fact,
Monday,
Your Lordship, we are available. We can do it tomorrow also. I can submit the document. My counsel can show you in the court only.
You cannot ask, because it is basically, governments borrow money from ADB, maybe from various sources, and they use it to enforce certain schemes, some projects, so and so. Whatever miscellaneous expenses are there, whatever has to be done, that has to be done by the government. It's no more the role of the lender of the money. Their role is that they are giving something, maybe as aid, maybe as, I don't know, as a grant, whatever. Then they are not bothered about whether you get 100 lakhs or you get 1 lakh or you get 50,000. That is not their issue. They have done it for a certain project, not for you to get money or something. That is not their idea. It's nowhere in the picture.
As per the agreement, they have certain parameters for granting rehabilitation and resettlement the JICA. So that has to be followed.
No, that has to be followed. But then over and above, if the law provides that it has to be given over and above that agreement, then the state is the responsibility of the state.
Now, only thing is that whether the JICA matrix is...
Your Lordship, if you pass over this matter for
Just
half
a
an
minute,
hour, I can...
just a minute.
Whether the benefit under the JICA matrix is more beneficial or benefit under the 2013 Act.
More beneficial. That's all. So that is all we have got to see. That is all they have got to show, in fact. And if it is more beneficial, it is not they who are supposed to pay. They have got no contract with you. It is between you and the person who has acquired your land.
State has accepted.
So the state has accepted. So it is.
Accepted saying that the JICA matrix is more beneficial than the
So that they'll have to show us that it is. So they will have to show us that it is more beneficial. They'll have to show us that it is less beneficial. That's all. And if it is more beneficial, the state law, then it's their duty to provide over and above what the JICA matrix provides. Yes, madam.
Tomorrow.
Yes, Your Lordship. If you want to see this loan agreement, what you have explained, Your Lordship, is absolutely correct. My loan agreement specifically says it is their duty. They are going to evaluate. They are going to pay this. I am funding the project, and whatever the purpose my funds can be used is also written in the loan agreement.
No, but what about the JICA matrix? What about the JICA matrix? Is there some matrix on how the rehabilitation should be done?
Your Lordship, JICA matrix, whatever they have calculated by using themselves only. My JICA guideline says it is the responsibility of the government to make the calculation, make the evaluation. I am not involved in the evaluation disbursement, so we don't know how on the fact basis matrix has been used. My JICA guidelines talks about the matrix, but if law of land is different, then law of land will vary.
Correct,
so JICA guidelines
correct.
is more relevant at that point of time.
It's very simple, you see. An agreement has to be as per the law of the land. It cannot be in violation of the law of the land. That's all. Now, if they have made an agreement between themselves, that is between them two. But the question of acquisition of your land is an agreement between, is a contract between you and the government and you, not between JICA. You see, if JICA matrix is lower, then the state has to provide as per the law. Anyway, so we can fix it on Monday.
Yes, Monday if possible, my lord.
Monday? Monday. I don't think you have got anything role to play out here. You'll be online.
Absolutely.
Okay, leave the matter on Monday. I think one item we have finished, but leave the matter on Monday.
Obliged, my lord.
Obliged.
Item number 8.
Wait, please, my lords. Am I audible and visible to my lords?
Item 8, yes, any objection?
My lord, this
38 days, Mr. Counsel, arbitration, this is arbitration, 38 days. After? 38 days after how many days? 120 days?
It was after 90 days.
After 90 days?
After 90 days.
No, but you are allowed only 120 days to file.
No, my lords, that's in 34. I am in 37 jurisdiction before my lords.
37.
120 days is a cap for 34, my lords, 34.3. I am today before my lords in 37.
And 37 provides for 30 days for filing.
My lords, 90 days is the limitation period, post which section 5 will apply and your lordships can condone the deal.
I don't know, let me see. 37. Because I think under 34, beyond 120 days we cannot condone.
That was for 34 minutes. We'll just have.
I think after 3 months, another 1 month can be given. Then after that, it's. And though there is a Supreme Court judgment, I think.
Your lordships are correct. Well, that provision is in relation to section 34. That's the first set of objections.
Let us see. Give me the Arbitration Act. Lekhabu ka daka. 2015.
December, January, February.
34 subclause 3, the proviso is what your lordships have referred to, right?
I think I can find.
May I read for your lordship's convenience?
Yes.
Well, it's 34 subclause 3 says, an application for setting aside may not be made after 3 months have elapsed from the date on which a party making the application has received the arbitral award, or if the party has made under section 33 from the date on which that request has been disposed of by the arbitral tribunal. And then comes the proviso ones. Provided that if the court is satisfied that the applicant was prevented by sufficient cause from making the application within the said period of 3 months, it may entertain the application within a further period of 30 days but not thereafter. That's the provision for 34.
So 120 days.
Right now is at the stage of section 37 minutes.
Okay.
The lordships will see at 37 actually there is no limitation as such prescribed. May I read for my lordship's convenience?
Yes.
Appealable orders?
Yes, please read.
Appealable orders. It's not there.
Please read.
Yes, minutes. Notwithstanding anything contained in any other law for time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decree of the court passing the order, namely, and my lords will just then see subclause 3, setting aside or refusing to set aside an arbitral award under section 34. Now your lordships will see the remaining part, subsection 2, an appeal shall also lie to a court from an order of the arbitral tribunal, and this then gives the scheme insofar as an order of arbitral tribunal is concerned, And then in subclause 3 it says no second appeal shall lie from the order passed in appeal under this section, but nothing in this section shall affect or take away a right of appeal to the Supreme Court.
Yes,
So
Mr.
this
Desi.
limitation is prescribed.
Yeah, my lord.
38 days.
Well, actually, we had lengthy hearing in these matters, and I was a very serious objection regarding they are ready to pay in that they had filed application for extension of time also. There, they are arranging funds.
Acha, this is the
Yes,
one.
yes, they are arranging funds. So they admitted that they are willing to pay, and even that.
And now they are challenging the.
Again, yes, they cannot blow hot and cold at the same time. So then
Not-
they
that would not
rely.
come in play.
It's not
I'll-
about the length of that, the delay, but yet they already admitted before the court. And then one grievance is that they are arranging fund. Another two is that the satellite, geo-satellite, that the image, they are waiting for that. But that cannot be the grounds for condonation of delay. Because they cannot issue new facts at all.
Now,
The power.
once my friend is done, I'll just address to my lords.
That's why your court condoned the delay of others matters, but this is a peculiar things. So since they already admitted before the trial court, and that they are, even if you like, Lordship would like to see also, I can read straight away also. They are arranging funds, they admitted, then again one point they are waiting for the image, the satellite
the
image.
peculiarity of the circumstances is this, my lords, that an additional payment has been directed for in the arbitral award for 1,237 trees. Your lordships will notice in the award.
That
if your lordships
fact will not into consideration.
Just a minute, 1 minute. We have given you time. You see, you cannot interject while one.
Yes, Lordship.
He was quiet.
beg your pardon.
It's your turn now to give him some respect. Yes.
Page 71, Malats, is the arbitral award. If your lordships will see, at the end of the day, Malats, even insofar as section 5 is concerned, the twin principle is that one, I have to satisfy your lordships that I was prevented by a sufficient cause. And second is that there should not be a miscarriage of justice. Today, Malats, 1 crore 27 lakh rupees of public exchequer is at stake. So therefore, Malats, in my respectful submission, there is a substantive cause, and prima facie, my lords, the report, the data daily report, the satellite imagery shows that it could not have been that there were 2,000 trees. And I will make good that argument. And dehodes all that, my lords will today see that the arbitral award is bereft of any reasoning whatsoever.
Then why did you make an application asking for time to pay the amount?
My lords, that is without prejudice to my right of filing an appeal. My lords will appreciate that part if your lordships will have para 7. What is being done by the arbitral award is that I am being bound by an admission of Kala. Kala comes before the arbitral tribunal and admits that Kala made an incorrect or an error and a mistake. I am fastened liability because of that. That, my lords, in my respectful submission, the Honorable Supreme Court has categorically said that one defendant, when in a suit where there are multiple defendants, one defendant cannot be bound by a admission of the second defendant or any other defendant. That's the category of law inside. So therefore, my lords, in my respectful submission, I have made out a good case on merits irrespective. And therefore, my lords, substantive justice would be defeated if your lordships today dismisses my condonation. Insofar as sufficient cause is concerned, my lords, one, I had procured a report. That report by itself took 60 days, 54 days to be precise, to get ready. And that's the time that has been lapsed. That is where the time lapsed. Second, when the award came, when the 34 petition came to the councils have raised queries.
Have you filed your written objection?
I filed already, my lord.
The problem is this is only a condonation of delay application. Whether we should go into the merits of, but then that was one reason, okay.
Your
because
lordships,
that application for extension of time if that was not there, then it would have been in time.
Yes.
But they have taken time there.
In fact, because of that, I withdrew
Well,
my
even
execution
most
petition
of
also. I filed execution petition. Because of that, they filed for extension. I withdraw that execution petition. They have come the court with unclean hands.
My lords,
My lord, the amount he submitted is not that 2 crore. This is only regarding it's not that high.
I said
And also
lakhs.
he traveled beyond his pleading, those things, that fact, it's not there in the continuation of delay application. Also, he cannot plead the merit of the case in that continuation also. Recent judgment, time and again, is been produced.
May I just point out to your lordships?
He cannot travel beyond the pleading.
Yeah, may I point out your lordships to the judgment of the Honorable Bombay High Court, which in fact shows that your lordships can consider it. 2015 to Maharashtra Law General. My colleague can hand it over to your lordships. It's called Chandrakant versus State of Maharashtra.
I think we will fix this for another day.
As you
Because
can.
I don't know, I've got a lot of judgments to write now. This one, this will take some amount of thinking, I think, because on the one hand, you have asked for time. Now, and then you have turned around and now challenging the award. So
Well, it's the challenge.
whether that asking for time and now turning around would amount to sufficient cause. We'll have to see that.
But the issue is that whether they can rely on other things which came after passing of the word.
So those things, whether I can look at it now.
But
That is
that in their continuation application, that is their main ground in their application.
Condemnation of delay application, I think there is a recent judgment, very recent, which says that what did you say, that
Substantive justice cannot be
substantive
denied.
justice, that should not be looked into. That is what I think the Supreme Court has said recently, the latest one.
Merit of the
I
case also.
analyze that aspect also.
Have you
I
read
analyze
it?
that aspect also.
Have you read it?
Well, to that extent, in fact, the Bombay High Court, right from 1962, analyzes the
I'm talking
position.
about the Supreme Court, I'm not talking about Bombay High Court.
It relies on the Supreme Court judgments
That
as
is
well.
a Supreme
Manoj.
Court judgment, recent, very recent, I think this week or last week.
Even merit of the case should not be looked into. Trivedi,
maybe,
Justice Trivedi passed that judgment also.
And the Trivedi, Justice Trivedi also passed, that is a different thing.
Yes.
Another one, very recent.
Can we have next week, Lordship? Then he will come. Because
Well, I am traveling for next 15 days. It can only be, if I only request, it can be after that.
Because here, my point is that it is not the length of the delay, the reason put forth in their condition of
That's
appeal.
what, this will require some thinking.
Yes. In some other
This will require
petition,
some thinking. Right, we'll list it, where are you going? London?
Well, down south only in
Down
India.
south, okay. I thought everyone goes to London, okay, right. On the request made on behalf of the applicant's counsel, this is the matter on. When?
my lord,
Well,
it's
it's
up-
any date after 15th or 16th. Any date after 16th.
my lord, this has to be taken up by your Lordship.
I know. I know. That's why I've been from Gauhati also I've been doing it virtually.
Yeah, fine it.
This is a matter on 21st. 21st.
21st June. 21st June. It's Sunday, I think.
Oh, sorry, I was looking at July. Okay. This is the matter.
22nd?
23rd. 22nd. Okay, 22nd.
Monday.
Much obliged, Lordship.
I'm so grateful, Milans.
Item number 9.
Yes.
My Lord,
Yes. Why didn't you file a contempt was too late? Where is the order in the writ petition? The earlier writ petition?
earlier writ petition, my Lord, it's in the main writ petition. Page 11. 11 to 19. That's the relevant portion of the order is at page 19, my Lord.
Yes. Madam, why haven't you paid?
Your Lordship, as per the last court order, Your Lordship, the IA has to be, it's regarding implement of...
Forget that. Why haven't you paid?
Your Lordship, on that regard, Your Lordship, we have not yet paid because this is a grant in aid school, Your Lordship, and the necessary party should also be the school involved, which is the Radha Mohan High School, Your Lordship, because...
Okay, so that's why it's not a part. Okay.
Yes, Lordship, and liberty had also been given to
Grant in
file...
aid school. Okay.
Yes, Your Lordship.
Okay, so we'll allow the application then.
My Lord. My Lord.
But you have to pay. The amount has to be paid. Right. Heard Mr. Efla Langley, and learned counsel for the senior counsel for the applicant who submits that the chairman, management committee, Radha Mohan High School, Kamla Nagar, Chongte-P, Mizoram, should be impleted as respondent number 5. Ms. Nalundri, learned government advocate, submits that she has got no objection to the same. Accordingly, so and so, same thing, is impleted as respondent number 5. Applicant to submit a fresh, corrected cost title.
My Lord,
You want to file an amended writ petition or what? What?
if page number 3 of the writ petition is allowed to be changed,
That's
then
what I
that
said.
will-
Corrected cost title.
My Lord, my Lord.
She has submitted a corrected cost title to the registry. I is accordingly disposed of. Then write in the main appeal, writ petition, in view of the order dated today, passed in IAC 111/2026, so and so has been impleted as respondent number 5. Issue notice to the respondent number 5. Next para. Petitioner to take steps for service of notice upon the respondent number 5 by speed post and through usual mode within 4 days. List the matter. Give a date after vacation.
14 July.
Much obliged, Your Lordship.
Deeply obliged.
Item 10.
Lordship,
Respondent number 5 have filed.
Yes,
your
Lordship,
affidavit.
we'll
When?
file. We'll file it.
Lordship, I would like to file rejoinder affidavit.
My Lord, nothing much there.
This morning only I received, and I would like to file.
She has
rejoinder.
filed. She received it today. We'll leave the matter another day. Why you want to file affidavit? You cannot keep on filing. What do you?
Because there is a new fact now.
Oh, new fact.
Yes.
Actually,
Which fact?
Yeah, they say that he allegedly purchased the portion which they claim from me.
So you have already said that they have not purchased.
Yes, I already said, but I have to counter his affidavit.
Okay.
My Lord, actually, you are inclined to dispose of also because of that you directed us in such a short time also to file it. That very, very simple. You have make 2 observations. The main issue, we have tourist lots. Then the acquired portion is that the fencing, the column there over there. Then they have their own property within that land that pass. So then in that the Kala they assess everything. Their share is around 17 lakhs something. Ours is from the assessment is only some 7 lakhs or something.
So they should get only their portion.
Definitely, we don't object that they have it, but they're trying to
take everything.
Everything. So even unfortunately,
you make your submissions on Monday. We'll hear
My
you
Lord,
on Monday.
my Lord, my client are residing in at Labong, and they have to
I have time to
Tell them
obtain
to
their
appear
signature.
online.
Because Monday is too early, my lord. I need to at least 2 weeks.
No.
The issue is very simple.
Why aren't you paying them their money? You want everything in your pocket.
Lordship, I want to say in my this one rejoinder affidavit whatever his submission.
The prayer for a rejoinder affidavit prayed for by Miss what? Jacinta.
Yes, my lord.
Hanmoy to the counter affidavit filed by the respondent number 5. Oh, which para?
Para number 4, they say that he or this search is land cover under periodic to the respondent number 5. And in para number 5, they mention about the work order issued by the Ministry of Tourism Department, but this is beyond our acknowledgement. Then number 6 are regarding this one allotment of the work order, and all that are out of my pleadings, and all these are the new issues.
You want to deny that you sold
Yes, my lord.
your land to the respondent number 5.
Yes, my lord.
You want to deny that?
Yes, my lord.
But my lord, there was a central scheme on 2021. We constructed 2 resorts for destination, and also we occupied.
No. So he wants to deny this statement of fact, that he had sold his land covered by this PP to the respondent number 5.
Well, the issue is the compensation amount, the 37 lakhs, which was deposit credited to their account on SBI account. Only that some portion, that the trees, that the zongtra or some other things.
Let me see the order passed by this court earlier.
My lord, order 27.5, it was very relevant. Last, you directed to file, the state to file additional affidavit.
Which page?
I think the last 20.
I have filed my affidavit on 4/7/2025. Your Lordship,
27.5.
The issue is very simple. So there was a land, rightly or wrongly, sale or no sale, by way of writing. It was owned by the tourism department. Now, after the place, tourist lodge was constructed, and it was finished, and it was occupied, then suddenly this land acquisition process has come into picture. Now they are taking a stand that they do not sell the land to the tourism department. It looks like an afterthought, but then the tourism department do not have a sale deed that is duly executed.
But then have the sale deed.
The sale deed. But then they paid him. They paid the 10 lakhs rupees. But then now they are saying that 10 lakhs rupees is for site development, not for sale. But nothing is written. However, at the time before disbursement,
so a sale deed was executed and exhibited.
It was not made at all. It was not made at all. However, before
land was their land.
Yeah, land was their land. It was allegedly both by the tourism department. Tourist lodge was built and occupied, and after occupation, then the land acquisition process has come up in 2021. So it was already occupied sometime in 2017-18. And after 2, 3, 4 years, then land acquisition process came up.
Okay, so the land, because
Yes,
the land was
yes.
still in the petitioner's name.
In petitioner's name.
So all the money went there.
All the money went there, but then before the money went there, the Kala had summoned the petitioner, and wherein he have stated before the Kala that okay, so and so, so and so. Now they are barred by the estoppel to say that we have already filed that.
It's in writing.
It is in writing,
Madam,
yes,
order
before the
27
Kala.
Order 27.
My lord, in this illegal occupation, the petitioner is filing civil suit before.
You deposit the money here to the court.
And Your Lordship, they have.
Lordship,
they have
Lordship, I just want to clarify my standpoint.
You clarify. We'll give you time to clarify and time to deposit the money also.
Your Lordship, if I may be kindly be allowed to submit my
Lordship,
statement.
I don't know whether my client is able to deposit or not.
No,
Because of that, I
that
have
is
to
the order.
consult first.
If they do not be
I have
able
to
to deposit,
consult
it will
first my
amount to
client.
contempt of the court,
Just a minute.
because the orders stated that they will be allowed to withdraw on the condition that they will, on the outcome of the case, they will deposit it back. That is the order. It will amount to contempt of court.
Lordship, in the this one, in the earlier order, if there is a reverse order, they have to deposit back.
Yes,
but
correct.
but
That
in
can
the-
always be modified. The writ court has the power to modify.
Anyway, my lord, I have to consult my client in this regard, and it is
No, your case is that you never sold the land. That's all. Correct.
yes. I had never sold my land to the tourism department, and in this respect, the illegal occupation, regarding the illegal occupation, I filed the civil suit before the Court of Senior Civil Justice.
When did you file? Actually, leaving that aside, when did they build the tourist lodge? And you were never aware of it.
I am aware of it, but I used to approach that tourism
and you took the 10 lakhs for site development.
site development
For
only.
whom? For your site development.
No, for my land site development, but
For
that
your
is not the purchase.
So
land.
they gave you free money. Even I want.
It is not a free. It is not a free money. That money was used for this one for taking clearance and all that.
Terrace. Tourism department does terrace work.
Tourism department had not given me that 10. That
Who
10
gave you
rupees.
the money?
Lusai Hills.
Lushai Hills gave you the money?
Yes.
Who is Lushai Hills?
Lusai.
It's an agency, yes, yeah, for
Engineering and
construction.
Constructed tourist lodge.
Oh, the Lushai Hills, that engineers.
Yes.
Okay.
The construction was completed in the year 2017. And the notification
Before
came
and
in
after,
2021.
before and after, we are approaching the tourism department.
Madam,
if they
I
want
think
to occupy.
Madam, I think you are shouting too much. I think it's time for you to pay. So we'll direct your client to come to this court on Monday. If he doesn't come, we'll issue warrant of arrest. Should we?
Lordship, Monday is too early.
Why?
Because
Why? How long does it take? Where does he stay? Where does he stay? Huh?
I think that he is staying in Klabong, but I don't
Klabong,
know that-
how long does it take?
Because long time I approach her, and these days I'm not approaching her. Because of that, I don't know
Okay,
whereabout
right.
of her.
What have I said? Huh? How did you say? The? No. Okay, that's it. Ms. Jacinta Zothanmoy, counsel for the petitioner, prays for time to file rejoinder affidavit to the affidavit filed by the respondent number 5. Though this court is not inclined to allow the said prayer, for the ends of justice, the petitioner is allowed to file the same by Monday. Failing which the matter will be heard without the said rejoinder affidavit. This is the matter on Monday.
Much obliged. Item 11.
Yes. Yes.
Your Lordship, this is a writ petition
Yes.
challenging the judicial order which has been stated yesterday. Your Lordship, the petitioners.
Where is that order that you have challenged?
Your Lordship?
Where is the order that you have challenged?
Yes.
The order dated 26 to pass says so, correct?
74. Page 74.
Yes, this order dated 26 to 2020. In eviction
Where is
suit
the
number-
rejection by the High Court?
Your Lordship?
Rejection of your order by the High Court?
The High Court had passed an order at page 93, Your Lordship, on 24/10/2025. This is an application filed under Section 5 of Limitation Act 1963, praying for condonation of delay of 1,883 days in filing the connected appeal against the order and decree dated 26/2/2020, passed by the Learned Senior Civil Judge 3 in eviction suit number 4 of 2019, as well as against the impugned order dated 13/7/2023, passed by the Learned Senior Civil Judge 4 in CMA number 416/2023, arising out of eviction suit number 4 of 2019. Lordship, delay was there and
rejected.
Finally, it was rejected. Application. In view of discussion above, this court is of the view that the applicant has not been able to show sufficient cause for delay of 1,883 days or even 775 days, and therefore this application, being devoid of merit, is dismissed. So the cause of the petitioners have come to an end on the dismissal or rejection of the application for condonation delay. Your Lordship, the applicants, the petitioners, were impleaded in the connected civil eviction suit, in the connected eviction suit 4 of 2019, and the suit was disposed of and decided ex parte against them because they were at one point of time given the notice, the summons, and they had appeared before the court and they had engaged one counsel to represent them. And after paying all necessary fees, finally they were informed that the suit was dismissed ex parte. So, Your Lordship, the petitioners are in a very difficult situation. Your Lordship, as I have stated here in the writ petition itself, in para 2 of my writ petition at page 4, Your Lordship will see that the petitioners are manual laborers, earning their livelihood by engaging themselves in chipping boulders for sale to various construction workers. Initially, they started working on the roadside of the new capital complex 2, Chonpui Road, near Ebenezer Hospital at Chonpui locality, Aizawl. Since they did not have a house of their own, They are to sleep under temporary sets erected on the work site where they used to prepare their meals and live thereat with great
Just give this
difficulties.
to him.
Way back in the year 2014.
Just look at para 27. Please read it loud since that's my only copy. Para 27.
Radicium.
Radicium.
Yes. Thus, we are of the view that judicial orders of civil courts are not amenable to a writ of certiorari under Article 226. We are also in agreement with the view of the referring bench that the writ of mandamus does not lie against a private person not discharging any public duty. Scope of Article 227 is different from Article 226. We may also deal, Lordship, this is finally the matter has been decided, and
Yes. So that is the law.
yes, Your Lordship, now I have also cited
Yes.
this, I have my citation.
Yes, you have your citation.
Yes.
How many judges?
Your Lordship,
And your citation is not on point also. How many judges?
so far as that is concerned, Your Lordship, the matter ends there. Matter ends there. But the thing is,
There is no
Your
case,
Lordship,
Mr.
there are some,
What to do? The law is like this.
the law has been settled in Radecium.
Correct.
And now that- now that
And it
since-
is a 3 judges bench.
Yes. Since there
And it has been-
there are some conflicting judgments,
No.
matter has been finally settled in Radicium.
Correct. There were 2 conflicting Supreme
now-
Court judgments settled.
And now, Your Lordship, my humble prayer is that there's a possibility of converting this writ into revision. under
No,
227.
there's no question of revision. Especially when you have gone in appeal and your appeal has been dismissed. There's no question of revision now. You go now in SLP. That's your only remedy left.
Your Lordship, for the petitioners,
What to do? I have to follow the law. If I do that to your case, tomorrow some other person will say, I'm a poor person,
Lordship,
I also should be
so
given
far
the
as
same.
the situation is concerned, the petitioners are, daily
And
laborers.
you have been very clever also in making a cost title. It is an eviction suit. A revenue department was necessary. Now in the writ petition, you have made the state of Mizoram as the first respondent. While all along it was private parties were there. Anyway, that is the tricks of the game, but then the law is clear. I cannot help.
Your Lordship, some difference may be carved out in respect of
No,
a decision
cannot.
which has been made
Cannot.
on the basis of fraud.
I am very clear.
Your Lordship,
You
may I
go,
take a Lordship?
you take this point before the Supreme Court. Then I have got no doubt in my mind that at least this court cannot do anything. Supreme Court can do everything because they have got Article 142 to do complete justice. They can do, but we don't have that power.
When the Supreme Court has laid down the law in respect of
Okay,
fraud,
now that judgment you are relying upon by the Supreme Court. Supposing I agree that it helps you. Supposing, how many judges bench?
3 judges.
3 judges.
Yes.
Who, let me see.
2025 SCC online. SC.
No, who are
151.
there? Where is the copy? Yeah.
Is there?
What does it say? What is
Lordship,
the issue?
Para 61.
Ah.
Para 61. In decisions abound, the courts have consistently nullified orders obtained through fraudulent means. Key excerpts from some of these decisions read thus. 1. A. In United India Insurance Company Limited, Rajendra Singh, this court reiterated that fraud unravels everything.
I agree.
Quote, fraud and justice.
I agree, but then you have got to prove fraud first. You've got to
I-
prove
I
for
have- I
first.
have,
But you
uh,
cannot do it in this manner. No, Mr.
I have to
cannot.
prove because when a thing that needs to be said
No, no, Mr.
that has been
Mr.
suppressed.
No, no, I cannot. Not in this manner. No case. I want to cut a long session short for the simple reason that my decision, I don't think I can change my view now. I will not, whatever you may argue, because this fact is clear. When you go in a civil suit, that suit has been, you challenge an order passed by a civil court, you can only challenge it in appeal, and in very, very, very exceptional cases under 227. You have gone in appeal, it has been rejected. Now you are coming in writ petition. The High Court has already rejected the proper procedure. Now, and out here it says that civil court decision cannot be challenged in a 226 petition. Dot on the point. I agree, fraud vitiates everything, but you have got to prove fraud. Out here, there's nothing, the decision is there.
Lordship, the respondent number 5, by suppressing the facts.
Maybe, I agree, maybe, but I cannot go into the merits.
Saying that the land which we are occupying is his.
You go in SLP, you go in SLP. It is not difficult. You go in SLP. You just have to give it to the Supreme Court Legal Service Authority. You give it there. They will take it up. But not by this court. Okay, right.
All right.
So, heard Mr. Sheila Ramzawa. Then you take this same order, yesterday's order. Yesterday's order. Then you take exactly the same. And I just made a ka dane, that, comma, that is IA Civil 112/2025. Wherein condonation of delay of 1883 days was prayed for under Section 5 of the Indian Limitation Act. The IA Civil 112 of 2025 was dismissed by this court. Was dismissed by order dated 24/10/2025 by holding that the applicant had not been able to show sufficient cause for the delay of 1883 days. Full stop. Next para. The petitioner has now filed the present writ petition under Article 226 of the Constitution, challenging the same impugned order dated 26/02/2020, passed in eviction suit number 4 of 2019, and submits that the validity of the above impugned order can be gone into, as there has been a fraud played by the private respondents. First up, in support of his submission, he has relied upon the judgment of the Supreme Court in the case of Vishnu Vardhan alias Vishnu Pradhan versus State of Uttar Pradesh and another, reported in 2025 SCC Online SC 1501. First up. Next para. Mr. Rosang Aralte, learned counsel for the appellant, for the respondent number 5. On the other hand, submits that the present writ petition should be dismissed as SCC 423. Full stop. I have heard the learned counsels for the parties. Full stop. As can be seen from the facts enumerated above, by the facts enumerated above, the petitioner is putting to challenge a judicial order of a civil court which had been dismissed by the appellate court on grounds of delay, by way of the present writ petition under Article 226 of the Constitution. Full stop. Next para. In the case of Vishnu Vardhan alias Vishnu Pradhan Supra, the Supreme Court had held that fraud avoids all judicial acts. Fraud. Held that a judgment, decree or order obtained by playing fraud on the court is a nullity and honest in the eye of the law. Full stop. This court does not have any issue. This court has the highest regard for the decision of the Supreme Court with the issue of the fact that fraud vitiates everything. Full stop. However, there is nothing in the impugned order to suggest that a fraud has been played upon the writ petitioner. Further, in view of the decision of
Lordship, if I am allowed to make some submission in that regard. Because
in the order, I'm saying, in the order, I'm not talking about the facts of the case. In the order, there's nothing to show. Only in the order, impugned order. I'm not saying it beyond that. Further, the issue of whether a fraud had been played or not is not the issue in the present case. The preliminary issue to be decided in this case is whether judicial orders of civil courts can be put to challenge in a writ proceeding under Article 226 of the Constitution. In the case of Radhe Shyam Supra, the Supreme Court had held that judicial orders of civil courts are not amenable to a writ of certiorari under Article 226. Full stop. Para 27 of the said judgment is reproduced herein below as follows. Full stop. Next, in view of the above facts, the present writ petition is not maintainable and is accordingly dismissed.
Lordship, protection may be given to the
No, 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 no,
petitioners
no, no, no,
in
nothing
view of the
like-
fact that, Your Lordship, the order which is under challenge.
No. Next.
Your Lordship,
Item 12. Sorry.
Stay be vacated.
Any interim order passed earlier stands vacated. Yes, notice has been served. So I've got a meeting at 4:30. I've got to rise.
My lord.
What is the matter about?
Enhancement of rate and inclusion of two structures.
No time. Okay. So
My lord, on the last occasions, your lordship had called the records of the arbitration.
Acha. Listed on Monday.
Yes. If a specific direction is passed in this regard, my lord, because only the records of the court in the appeal had reached the court.
Only at the appeal?
Yes. The arbitrator's records have not reached this court. So perhaps a specific order may be passed by your lordship.
Yes, registry as only the only the civil court's records have been received. Registry to direct the arbitrator to provide the records pertaining to the matter. List the matter on Monday or Tuesday. Tuesday.
Deeply obliged.
Okay.
My lords, if I may, I understand the paucity of time, but there is one item, part 2 item fixed for today, so this can be taken up after a week, my lord.
What item?
Item 4, my lord.
What is that about?
It's a criminal appeal, my lord.
Okay. Next week. Okay.
3 weeks,
Why?
my lord, yes.
Is it?
Yes,
Okay.
yes, I'm on board.
On the prayer of the parties, list the matter after 3 weeks.
Yes, my lord. And item 5 is also fixed for. Part 2, item 5 is also fixed for today. This can come up after a week, my lord.
Okay.
Obliged.
No, on the prayer of the party, list the matter after.